Today's topic is constructive receipt. And if you're an attorney who has a client who's considering a structured settlement, or a financial planner with a client who's considering a structured settlement, constructive receipt is something that you must avoid, because constructive receipt is a structured settlement killer. What is constructive receipt? Constructive receipt basically means that money is not subject to any more restrictions. For example, there's nothing holding back the defendant from issuing a check or you cashing a check in certain circumstances. For example, a plaintiff attorney could sign a general release. Very often at the end of cases, you have defense counsel who, in addition to a structured settlement document, may put out a standard general release. And the standard general release says the case is settled for $1 million. Well, that $1 million includes the cost of future periodic payments, which might be paying a lot more than that $1 million. But if you sign a general release that says $1 million and then you have another document that says something completely different, it leaves it open for discussion in the future, and that may not be very good for your client. So when you have a structured settlement, it's very important to avoid constructive receipt. If you have releases that say in consideration for a single cash lump sum, especially when it says the receipt and sufficiency of which is hereby acknowledged, you ought to rethink what you're doing or think carefully before you send it back. Once you send it back, it's possible that you've now essentially killed your client's ability to do a structured settlement. So avoid it. And if you're a plaintiff and you see if you want a structured settlement and you see a document that says it's settled for a lump sum of cash when you want a structured settlement, then don't sign the document and raise your hand or ask your attorney, are you sure this is something that I should be signing? Because once you cross over that threshold and you've signed that release and you've delivered it to the defense, there's nothing there holding back them issuing a check. And in some cases, they may not agree to sign any other documents because you've already signed this release for cash. You also have to be careful when you are in a mediation. Sometimes you're in a mediation, you spent a whole day in a mediation, and then you blow it. It gets blown at the end because you sign a release that says it's for cash. It's very, very important if you want a structured settlement to make sure that periodic payments are expressed very carefully and documented in the settlement papers, whether it be a mediation statement or the actual final settlement agreement release. Thank you. This is a continuation of our education series on the basics of structured settlements. Have a great day.